Double jeopardy. Discuss the right of every accused against double jeopardy. Answer. Article 3:21 of the new Constitution reads, no person shall be twice put in jeopardy of punishment for the same offense. If an act is punished by a law, and an ordinance, conviction, or acquittal under either shall constitute a bar to another prosecution for the same act. The first sentence sets forth the general rule. The constitutional protection against double jeopardy is not available where the second prosecution is for an offense that is different from the offense charged in the first or prior prosecution, although both the first and second offenses may be based upon the same act or set of acts. The second sentence embodies an exemption to the general proposition. Exception to the general proposition. The constitutional protection against double jeopardy is available although the prior offense charged under an ordinance be different from the offense charged subsequently under a national statute such as the revised penal code, provided that both offenses spring from the same act or set of acts. Requisites. Question. What are the requisites of double jeopardy? Answer. Double jeopardy exists when the following requisites are present. A. A first jeopardy is attached prior to the second. B. The first jeopardy has been validly terminated. And C. A second jeopardy is for the same offense as in the first. A jeopardy attaches only A. After a valid indictment, B. Before a competent court, C. After arraignment, D. When a valid plea has been entered, and E. When the accused has been acquitted or convicted, or the case dismissed or otherwise terminated without his express consent. Cerezo v. People, GR 185230. Question. On October 21, 1986, 17-year-old Virginia Sagrado brought a complaint against Martin Geralde for consented abduction. When the accused pleading not guilty of an arraignment, trial ensued. After trial, a judgment of conviction was rendered against Geralde. When the case was appealed to it, the Court of Appeals reversed the judgment of the trial court, rationating the rule as follows. This is not to say that the appellant did nothing wrong. She was seduced by the appellant with promises of marriage just to accomplish his lewd designs. Years later, Virginia brought another complaint for qualified seduction. Geralde presented a motion to quash on the ground of double jeopardy, which motion and his subsequent motion for reconsideration were denied. Question. May Geralde validly invoke double jeopardy in questioning the institution of the case for qualified seduction? He placed reliance principally on the same evidence test to support his stance. He assured that the offenses with which he was charged arose from the same set of facts. Furthermore, he averted that the complaint for qualified seduction is barred by waiver and estoppel on the part of the complainant, she having opted to consider the case as consented abduction. Finally, he argued that her delay of more than 8 years before filing the second case against him constituted pardon on the part of the offended party. How would you resolve Geralde's contentions? Explain. A. Geralde's invocation of double jeopardy is improper. Although the two crimes may have arisen from the same set of facts, they are not identical offenses as would make applicable the rule on double jeopardy. The aggravement of the offense of the abduction of a woman with her own consent who is still under the control of her parents or guardian is the alarm and perturbance to the parents and family of the abducted person, and the infringement of the rights of the parent or guardian. In cases of seduction, the aggravement of the offense is the wrong done the young woman who is seduced. Moreover, Virginia's filing of a subsequent case against the accused belies his allegation that she has waived or is stopped from filing the second charge against him. Neither could she be deemed to have pardoned him, nor the rules require that in case of seduction, abduction, rape, and acts of lasciviousness, pardon by the offended party to be effective must be expressly given. Rule 110, Section 4 of the Rules of Court. Moreover, The length of time it took her to file the second case is of no moment considering that she filed it within the 10-year prescriptive period. Article 19 RPC Perez versus CA. Q. Charged by Francisco with libel. Pablo was arraigned on January 3, 2000. Pre-trial was dispensed with and continuous trial was set for March 7, 8, and 9, 2000. On the first setting, the prosecution moved for its postponement and cancellation of the other settings because its principal and probably only witness, the private complainant Francisco, suddenly had to go abroad to fulfill a professional commitment. The judge instead dismissed the case for failure to prosecute. Would the reversal of the trial's court assail dismissal of the case place the accused in double jeopardy? Answer: no. The reversal of the trial court's assailed dismissal of the case would not place the accused in double jeopardy. While generally dismissal of case on the ground of failure to prosecute predicated on the clear right of the accused to speedy trial is equivalent to an acquittal that would bar further prosecution of the accused for the same offense, the same rule is not applicable in this case, considering that the right of the accused to speedy trial has not been violated by the state. For this reason, Pablo cannot invoke his right against double jeopardy. People v. Tampal, GR 102485. Q. For the death of Joey, Erning was charged with the crime of homicide before the Regional Trial Court of Valenzuela. He was arraigned due to numerous postponements of the scheduled hearings of the instance of the prosecution, particularly based on ground of unavailability of prosecution, witnesses who could not be found or located. The criminal case was pending trial for a period of 7 years. Upon motion of accused Erring, who invoked his right to speedy trial, the court dismissed the case. Eventually, the prosecution witnesses surfaced, and a criminal case for homicide involving the same incident was filed anew against Erning. Accused Erning moved for dismissal of the case on the ground of double jeopardy. The prosecution objected, submitting the reason that it was not able to present the said witnesses earlier because the latter went into hiding out of fear. Resolve the motion. Answer: the motion should be granted, as held in C. Saez versus IAC 179-54. The dismissal of a criminal case predicated on the right of the accused to a speedy trial amounts to an acquittal for failure of the prosecution to prove his guilt and bars his subsequent prosecution for the same offense. Q. A Tamara FX, driven by Astyong Cascasero, who was drunk, sideswiped a pedestrian along EDSA in Makati City, resulting in physical injuries to the latter. The public prosecutor filed 2 separate informations against Cascasero, the first for reckless imprudence resulting in physical injuries under the revised penal code, and the second for violation of an ordinance of Makati City prohibiting and penalizing driver under the influence of liquor. Cascasero was arraigned, tried, and convicted for reckless imprudence resulting in physical injuries under the revised penal code. With regard to the second case, violation of the city ordinance, upon being arraigned, he filed a motion to quash the information, invoking his right against double jeopardy. He contended that under Article 3, Section 21 of the Constitution, if an act is punished by a law and an ordinance, conviction or acquittal under either shall constitute a bar to another prosecution for the same act. He argued that the 2 criminal charges against him stemmed from the same act of driving allegedly under the influence of liquor, which caused the accident. Was there double jeopardy? Explain your answer. Answer: yes, there was double jeopardy. The constitutional protection against double jeopardy is available so long as the acts which constitute or have given rise to the first offense under a municipal ordinance are the same acts which constitute or having given rise to the offense charged under a statute. In this case, the same act is involved in the 2 cases. The reckless imprudence which resulted in physical injuries arose from the same act of driving under the influence of liquor. The fact that the 2 charges sprung from one and the same act of conviction or acquittal under either the law or the ordinance shall bar a prosecution under the other, thus making it against the logic of double jeopardy. Q. But Choi installed a jumper cable. He was prosecuted under a Makati ordinance penalizing such act. He moved for its dismissal on the ground that the jumper cable was within the territorial jurisdiction of Mandaluyong and not Makati. The case was dismissed. The city of Mandaluyong thereafter filed a case against him for theft under the revised penal code. Is there double jeopardy? Double jeopardy? A. No, the first jeopardy was terminated with his express consent. B. Yes, there is double jeopardy of the second kind, prosecution for the same act under an ordinance and a law. C. Yes, he is prosecuted for the same offense, which has already been dismissed by the city of Makati. And D. No, the second kind of double jeopardy under Section 21, Article 3 under contemplates conviction or acquittal which could terminate a first jeopardy, 2012 bar. Answer, letter D. No, the second kind of double jeopardy under Section 21, Article 3 only contemplates conviction or acquittal which could terminate a first jeopardy. Citizenship, Filipino citizens. Q. From mainland China, where he was born of Chinese parents, Mr. Nia Cha Chan migrated to the Philippines in 1894. As of April 11, 1899, he was already a permanent resident of the Philippines and continued to reside in this country until his death. During his lifetime and when he was already in the Philippines, Mr. Nia Cha Chan married Charing, a Filipina, with whom he begot one son, Hap Chan, who was born on October 18, 1897. Hap Chan got married also to Nympha, a Filipina, and one of their children was Lucky Chan, who was born on September 27, 1936. Lucky Chan finished the course Bachelor of Science in Commerce and eventually engaged in business. In the May 1989 election, Lucky Chan ran for and was elected representative or congressman. His rival candidate Ramon de Loria filed a quo warranto or disqualification case against him on the ground that he was not a Filipino citizen. It was pointed out in particular that Lucky Chan did not elect Philippine citizenship upon reaching the age of 21. Decide whether Mr. Lucky Chan suffers from a disqualification or not. Answer. Lucky Chan is a Filipino citizen and need not elect Philippine citizenship. His father, Hap Chan, was Spanish subject, was residing in the Philippines on April 11, 1899, and continued to reside in the Philippines. In accordance with Section 4 of the Philippine Bill of 1902, he was Filipino citizen. Hence, in accordance with Section 1, number 3 of the 1935 Constitution, Lucky Chan is a natural-born Filipino citizen since his father was a Filipino citizen. Q. Miguel Sin was born a year ago in China to a Chinese father and a Filipino mother. His parents met in Shanghai, where they were lawfully married just 2 years ago. Is Miguel Sin a Filipino citizen? Answer, yes. Miguel Sin is a Filipino citizen because he is the legitimate child of Filipino mother. Under Article 4, Section 4 of the 1987 Constitution, his mother retained her Philippine citizenship despite her marriage to an alien husband. And according to Article 4, Section 1, Number 2 of 1987 Constitution, children born of a Filipino mother are Filipino citizens. Q. Attorney Emily Go, a legitimate daughter of a Chinese father and a Filipino mother, was born in 1945. At 21, she elected Philippine citizenship and studied law. She passed the bar examinations and engaged in private practice for many years. The Judicial and Bar Council nominated her as a candidate for the position of Associate Justice of the Supreme Court, but her nomination is being contested by Attorney Juris Castillo, also an aspirant to the position. She claims that Attorney Emily Go is not a natural-born Filipino citizen, hence not qualified to be appointed to the Supreme Court. Is this contention correct? Answer. The contention that Attorney Emily Go is not a natural-born citizen is not correct. She was born before January 17, 1973 of a Chinese father and a Filipino mother. She elected Philippine citizenship when she reached 21 years of age. Those who elect Philippine citizenship under Section 1, Number 3, Article 4 of the Constitution are natural-born Philippine citizens. Q. Attorney Richard Chua was born in 1964. He is a legitimate son of a Chinese father and a Filipino mother. His father became a naturalized Filipino citizen when Attorney Chua was still a minor. Eventually, he studied law and was allowed by the Supreme Court to take the bar examination, subject to his submission to the Supreme Court proof of his Philippine citizenship. Although he never complied with such requirement, Attorney Chua practiced law for many years until one Noel Eugenio filed with the Supreme Court a complaint for disbarment against him on the ground that he is not a Filipino citizen. He then filed with the Bureau of Immigration an affidavit electing Philippine citizenship. Noel contested it, claiming it was filed many years after Attorney Chua reached the age of majority. Will Attorney Chua be disbarred? Explain. Answer. Attorney William Chua should not be disbarred. In accordance with Section 15 of the Revised Naturalization Act, he became a naturalized Philippine citizen when his father became a Filipino citizen during his minority. Hence, there was no need for him to elect Philippine citizenship. Co versus HRET. Q. Edwin Nicasio, born in the Philippines of Filipino parents and raised in the province of Nueva Ecija, ran for governor of his home province. He won and was sworn into office. It was recently revealed, however, that Nicasio is a naturalized American citizen. Does he still possess Philippine citizenship? If Nicasio was born in the United States, would he be still a citizen of the Philippines? Answer. First, no. Nicasio no longer possessed Philippine citizenship as held in Frivaldo versus Commission on Election. By becoming a naturalized American citizen, Nicasio lost his Philippine citizenship under Section 1, Number 1 of Commonwealth Act Number 63. Philippine citizenship is lost by naturalization in a foreign country. B. If Nicasio was born in the United States, he would still be a citizen of the Philippines since his parents are Filipinos under Section 1, Number 2. Those whose fathers or mothers are citizens of the Philippines are citizens of the Philippines. Nicasio would possess dual citizenship since under American law, persons born in the United States are American citizens as held in Aznar versus Comelec. A person who possesses both Philippine and American citizenship is still a Filipino and does not lose his Philippine citizenship unless he renounces it. Q. Discuss the evolution of the principles of jus sanguinis as basis of Filipino citizenship under the 1935, 1973, and 1987 Constitution. 2015 bar. Answer. Section 1, Article 3 of the 1935 Constitution adopted the jus sanguinis principles as the basis of the Filipino citizenship if the father is a Filipino citizen. However, subsection 4, Section 1, Article 3 of the Constitution provided that if the mother was a Filipino citizen who lost her Philippine citizenship because of her marriage to a foreign husband, her children could elect Philippine citizenship upon reaching the age of majority. Subsection 2, Section 1, Article 3 of the 1973 Constitution provided that a child born of a father or a mother who is a citizen of the Philippines is a Filipino citizen. Section 2, Article 3 of the 1973 Constitution provided that a child whose father or mother is a Filipino citizen is a Filipino citizen. Subsection 3, Section 1, Article 4 of the 1987 Constitution provided that a child born before January 17, 1973 of Filipino mothers who elected Philippine citizenship upon reaching the age of majority under the 1973 Constitution is a natural-born Filipino citizen. Texan versus Comelec. Modes of acquiring citizenship. Q. Are the effects of marriage of 1. A citizen to an alien, 2. An alien to a citizen, on their spouses and children. Discuss. Answer. 1. According to Section 4, Article 4 of the Constitution, Filipino citizens who marry aliens return their citizenship, unless by their act or omission they are deemed under the law to have renounced it. Number 2. According to Mo Yao Lim Yao versus Commissioner of Immigration, 41 Squa 292. Under Section 15 of the Revised Naturalization Law, a foreign woman who marries a Filipino citizen becomes a Filipino citizen provided she possesses none of the disqualifications for naturalization. A foreign man who marries a Filipino citizen does not acquire Philippine citizenship. However, under Section 3 of the Revised Naturalization Act, in such a case, the residence requirement for naturalization will be reduced from 10 to 5 years under Section 1, Number 2, Article 4 of the Constitution. the children of an alien and a Filipino citizens are citizens of the Philippines. Q. Rosebud is a natural-born Filipino woman who got married to Rock Cold, a citizen of state Frozen. By virtue of the laws of Frozen, any person who marries its citizen would automatically be deemed its own citizen. After 10 years of marriage, Rosebud, who has split her time between the Philippines and Frozen, decided to run for Congress. Her opponent sought her disqualification, however, claiming that she is no longer a natural-born citizen. In any event, she could not seek elective position since she never renounced her foreign citizenship pursuant to the Citizenship Retention and Reacquisition Act 9225. Is Rosebud disqualified to run by reason of citizenship? Answer is no, because Rosebud never lost her status as a natural-born citizen by reason of marriage to a foreigner. In addition to her status as a natural-born citizen, she acquired the citizenship of her husband by operation of law and not by voluntary act of acquisition thereof and voluntary renunciation of her former citizenship. In relation to election protest, what is prohibited is dual allegiance. Allegiance to a foreign state is acquired through an express and voluntary act of renouncing one's allegiance to the Republic of the Philippines and swearing allegiance to a foreign state, example enlisting in the military services of another state. Naturalization and denaturalization. Question. Enzo, a Chinese national, was granted Philippine citizenship in a decision rendered by the Court of First Instance of Pampanga on January 10, 1956. He took his oath of office in June 5, 1959. In 1970, the Solicitor General filed a petition to cancel his citizenship on the ground that in July 1969, the Court of Tax Appeals found that Enzo had cheated the government of income taxes for the years 1956 to 1959. Said decision of the tax court was affirmed by the Supreme Court in 1969. Between 1960 and 1970, Enzo had acquired substantial real property in the Philippines. Has the action for cancellation of Enzo's citizenship prescribed? B. Can Enzo ask for the denial of the petition on the ground that he had availed of the tax amnesty for his tax liabilities? C. What is the effect on the petition for cancellation of Enzo's citizenship if Enzo died during the pendency of the hearing of said petition? Answer. Letter A. No. The action is not prescribed as held in Republic v. Lee Yao. A certificate of naturalization may be cancelled at any time if it was fraudulently obtained by misleading the court regarding the moral character of the petitioner. Letter B. No, Enzo cannot ask for the denial of the petition for the cancellation of a certificate of naturalization on the ground that he had availed of the tax amnesty. In accordance with a ruling in Republic v. Lee Yao 224-748, the tax amnesty merely removed all the civil, criminal, and administrative liabilities of Enzo. It did not obliterate his lack of good moral character and irreproachable conduct. C. On the assumption that he left a family, the death of Enzo does not render the petition for the cancellation of a certificate of naturalization moot. As held in Republic v. Lee Yao 224-748, the outcome of the case will affect his wife and children. Q. Lim Tong Biao, a Chinese citizen, applied for and was granted Philippine citizenship by the court. He took his oath as citizen of the Philippines in July 1963. In 1975, the Office of the Solicitor General filed a petition to cancel his Philippine citizenship for the reason that, in August 1963, the Court of Tax Appeals found that he is guilty of tax evasion for deliberately understating his income taxes for the years 1959 to 1961. Question A. Could Lim Tong Biao raise the defense of prescription of the action for cancellation of his Filipino citizenship? B. Supposing Lim Tong Biao had availed of the tax amnesty of the government for his tax liabilities, would this constitute a valid defense to the cancellation of Filipino citizenship? Answer. Letter A. No. Lim Tong Biao cannot raise the defense of prescription, as held in Republic v. Go Bon Lee. A decision granting citizenship is not res judicata, and the right of the government to ask for the cancellation of a certificate cancellation is not barred by the lapse of time. Letter B. The fact that Lim Tong Biao availed of the tax amnesty is not a valid defense to the cancellation of his Filipino citizenship. In Republic versus Liao, the Supreme Court held that tax amnesty does not have the effect of obliterating his lack of good moral character and reproachable conduct, which are grounds for denaturalization. Dual citizenship and dual allegiance, true or false? Dual citizenship is not the same as dual allegiance. Answer, true. Dual citizenship arises when, as a result of the concurrent application of the different laws of two or more states, a person is simultaneously considered a national by those states and is involuntary. On the other hand, dual allegiance refers to the situation in which a person simultaneously owes to some positive and voluntary act loyalty to two or more states. Mercado versus Manzano. Loss and reacquisition of Philippine citizenship. Julio Hortal was born of Filipino parents. Upon reaching the age of majority, he became a naturalized citizen in another country. Later, he reacquired Philippine citizenship. Could Hortal regain his status as natural-born Filipino citizen? Would your answer be the same whether he reacquires his Filipino citizenship by repatriation or by act of Congress? Explain. Answer. Julio Mortal can regain his status as a natural-born citizen by repatriating. Since repatriation involves a restoration of a person to citizenship previously lost by expatriation, and Julio Mortal was previously a natural-born citizen. In case he repatriates, he will be restored to his status as a natural-born citizen. If he reacquired his citizenship by an act of Congress, Julio Hortal will not be a natural-born citizen since he reacquired his citizenship by legislative naturalization. Q. Cruz, a Filipino by birth, became an American citizen. In his old age, he has returned to the country and wants to become a Filipino again. As his lawyer, enumerate the ways by which citizenship may be reacquired. Answer. Cruz may reacquire Philippine citizenship in the following ways. 1. By naturalization. 2. By repatriation, pursuant to Republic Act No. 8171. And 3. By direct act of Congress, Section 2 of Commonwealth Act No. 63. Q. Warlito, a natural-born Filipino, took up permanent residence in the United States and eventually acquired American citizenship. He then married Shirley, an American, and sired 3 children. In August 2009, Warlito decided to visit the Philippines with his wife and children, Johnny, 23, Warlito Jr., 20, and Luisa, 17. While in the Philippines, a friend informed him that he could reacquire Philippine citizenship without necessarily losing U.S. nationality. Thus, he took the oath of allegiance, reacquired under RA 9225. Having reacquired Philippine citizenship, is Warlito a natural-born or a naturalized Filipino citizen today? Explain your answer. Answer. Warlito is a natural-born Filipino citizen. Repatriation of Filipinos result in the recovery of his original nationality. Since Warlito was a natural-born citizen before he lost his Philippine citizenship, he was restored to his former status as a natural-born Filipino citizen. Bengson versus House of Representative Electoral Tribunal. B. With Warlito having regained Philippine citizenship, will Shirley also become a Filipino citizen? If so, why not? If not, what would be the most speedy procedure for Shirley to acquire Philippine citizenship? Explain. A. Shirley will not become a Filipino citizen because under RA 9225, Warlito's reacquisition of Philippine citizenship did not extend its benefits to Shirley. She should instead file with the Bureau of Immigration a petition for the cancellation of her alien certificate of registration on the ground that in accordance with Section 15 of the Naturalization Law, because of her marriage with Warlito, she should be deemed to have become a Filipino citizen. She must allege and prove that she possessed none of the disqualification to become a naturalized Filipino. Burka versus Republic. Do the children, Johnny, Warlito Jr., and Luisa, become Filipino citizens with their father's reacquisition of Philippine citizenship? Explain your answer. Answer. Under Section 18 of RA 9225, only the unmarried children who are below 18 years of age of those who reacquire Philippine citizenship shall be deemed Filipino citizens. Thus, only Luisa, who is 17 years old, became a Filipino citizen. Natural-born citizens and public office. Q. In 1989, Zenny Reyes married Ben Tulog. a national of the state of Congo. Under the laws of Congo, an alien woman marrying a Congo national automatically acquires Congo citizenship. After her marriage, Seni resided in Congo and acquired a Congo passport. In 1991, Seni returned to the Philippines to run for governor of Sorsogon. A. Was Zeni qualified to run for governor? B. Suppose instead of entering politics, Zeni just got herself elected as vice president of the Philippines Bulletin, a local newspaper. Was she qualified to hold that position? Answer: letter A. Under Section 4, Article 4 of the Constitution, Seni regained her Filipino citizenship. Since she also became a citizen of Congo, she possesses dual citizenship. Pursuant to Section 40, letter D of the Local Government Code, she is disqualified to run for governor. In addition, if Seni returned to the Philippines less than a year immediately before the day of the election, Seni is not qualified to run for governor of Sorsogon. Under Section 39, letter A of the Local Government Code, a candidate for a governor must be a resident in the province where he intends to run at least 1 year, immediately preceding the day of the election. By residing in Congo upon her marriage in 1989, Seni abandoned her residence in the Philippines. This is in accordance with the decision in Kaasi versus Court of Appeals. Alternative answer: no. Seni was not qualified to run for governor. Under the Constitution, citizens of the Philippines who marry aliens shall retain their citizenship unless by their act or omission they are deemed under the law to have renounced it. Section 4, Article 4, Constitution. Her residing in Congo and acquiring a Congo passport are indicative of her renunciation of Philippine citizenship, which is a ground for loss of her citizenship, which she was supposed to have retained. When she ran for governor of Sorsogon, Seni was no longer a Filipino citizen and hence was disqualified for said position. Letter B. Although under Section 11, Number 1, Article 16 of the Constitution, mass media must be wholly owned by the Filipino citizens, and under Section 2 of the Anti-Dummy Law, aliens may not intervene in the management of any nationalized business activity. Seni may be elected Vice President of the Philippine Bulletin because she has remained a Filipino citizen. Under Section 4, Article 4 of the Constitution, Filipino citizens who marry aliens retains their citizenship unless by their act or omission they are deemed under the law to have renounced it. Seni is not guilty of any acts or omission which will result in loss of citizenship, are enumerated in Commonwealth Act No. 63. As held in Kawakita versus United States, a person who possesses dual citizenship like Seni may exercise rights of citizenship in both countries, and the use of a passport pertaining to one country does not result in loss of citizenship in other country. And there is another alternative answer. Neither was Seni qualified to hold the position of Vice President of Philippine Bulletin. Under the Constitution, the ownership and management of mass media shall be limited to citizens of the Philippines, or to corporations, cooperatives, or associations wholly owned and managed by such citizens. Section 11, Number 1, Article 16. Being a non-Philippine citizen, Seni cannot qualify to participate in the management of the bulletin as vice president thereof. Q. Andres Ang was born of a Chinese father and a Filipino mother in Sorsogon, on January 20, 1973. In 1988, his father was naturalized as a Filipino citizen. On May 11, 1998, Andres Ang was elected representative of the 1st District of Sorsogon. Juan Bunto, who received the second highest number of votes, filed a petition of co-warranto against Ang. The petition was filed with the HRET. Bonto contends that Ang is not a natural-born citizen of the Philippines and therefore is disqualified to be a member of the House. The HRET, the House of the Representative Electoral Tribunal, ruled in favor of Ang. Bonto filed a petition for certiorari in the Supreme Court. The following issue is raised: whether Ang is a natural-born citizen of the Philippines. How should this case be decided? Answer: Andres Ang should be considered a natural-born citizen of the Philippines. He was born of a Filipino mother on January 20, 1973. This was after the effectivity of the 1973 Constitution on January 17, 1973. Under Section 1, Article 6 of the 1973 Constitution, those whose fathers or mothers are citizens of the Philippines are citizens of the Philippines. Andres Ang remained a citizen of the Philippines after the effectivity of the 1987 Constitution. Section 1, Article 4 of the 1987 Constitution provides the following are citizens of the Philippines. 1. Those who are citizens of the Philippines at the time of the adoption of this Constitution. Q. A was born in the Philippines of Filipino parents. When martial law was declared in the Philippines on September 21, 1972, he went to the United States and was naturalized an American citizen. After the EDSA revolution, he came home to the Philippines and later on reacquired Philippine citizenship by repatriation. Suppose in the May 2004 election he is elected member of the House of Representatives and a case is filed seeking his disqualification on the ground that he is not a natural-born citizen of the Philippines. How should the case against him be decided? Explain your answer. Answer: the case should be decided in favor of A. As held in Bengson versus HRET, repatriation results in the recovery of the original nationality. Since A was a natural-born Filipino citizen before he became a naturalized American citizen, he was restored to his former status as a natural-born Filipino when he repatriated. Q. Juan Cruz was born of Filipino parents in 1960 in Pampanga. In 1985, he enlisted in the U.S. Marine Corps and took an oath of allegiance to the United States of America. In 1990, he was naturalized an American citizen. In 1994, he was repatriated under Republic Act No. 2430. During the 1998 national elections, he ran for and was elected representative of the 1st District of Pampanga, where he resided since his repatriation. Was he qualified to run for the position? Explain. Answer: Cruz was qualified to run as representative of the 1st District of Pampanga. Since his parents were Filipino citizens, he was a natural-born citizen, although he became a naturalized American citizen under the ruling in Bengson versus HRET. By virtue of his repatriation, Cruz was restored to his original status as natural-born Filipino citizen. Q. TCA, a Filipino medical technologist, left in 1975 to work in Sault Ste. In 1988, he married ODH, a citizen of ZOC. Pursuant to ZOC's law, by taking an oath of allegiance, she acquired her husband's citizenship. ODH died in 2001, leaving her financially secured. She returned home in 2002 and sought elective office in 2004 by running for mayor of APP, her hometown. Her opponent sought to have her disqualified because of her COC citizenship. She replied that although she acquired COC citizenship because of marriage, she did not lose her Filipino citizenship. Both her parents, she said, are Filipino citizens. Is TCA qualified to run for mayor? Answer: on the assumption that TCA took an oath of allegiance to COC to acquire the citizenship of her husband, she is not qualified to run for mayor. She did not become a citizen of COC merely by virtue of her marriage. She also took an oath of allegiance to COC. By this act, she lost her Philippine citizenship. Section 1, Number 3, Commonwealth Act of 63. Law on Public Officers. Q. State at least 3 constitutional provisions reflecting the state policy on transparency in matters of public interest. What is the purpose of said policy? A. The following are the constitutional provisions reflecting the state policy on transparency in matters of public interest. Number 1. Subject to reasonable conditions prescribed by law, the state adopts and implements a policy of full public disclosure of all its transactions involving public interest. Section 28, Article 2. The right of the people to information on matters of public concern shall be recognized. Access to official records and to documents and papers pertaining to official acts, transactions, or decisions, as well as to government research data used as basis for policy development, shall be afforded to citizens, subject to such limitations as may be provided by law. Section 7, Article 3. Number 3. The records in books of accounts of the Congress shall be preserved and be open to the public in accordance with law, and such books shall be audited by the Commission on Audit, which shall publish annually an itemized list of amounts paid to and expenses incurred for each member. Section 20, Article 6. Number 4. The office of the Ombudsman shall have the following powers, functions, and duties. Number 6. Publicize matters covered by its investigation when circumstances so warrant and with due prudence. Section 12, Article 11. Number 5. A public officer or employee shall, upon assumption of office and as often as thereafter may be required by law, submit a declaration under oath of his assets, liabilities, and net worth. In the case of the President, the Vice President, the members of the Cabinet, the Congress, the Supreme Court, the Constitutional Commission, and other constitutional offices and offices of the armed forces with general or flag rank, the declaration shall be disclosed to the public in the manner provided by law. Section 17, Article 11. And 6. Information on foreign loans obtained or guaranteed by the government shall be made available to the public. Section 21, Article 12. As explained in Valmonte versus Belmonte, the purpose of the policy is to protect the people from abuse of governmental power. If access to information of public concern is denied, the postulate public office is a public trust would be mere empty words. Modes and kinds of appointment. Q. In December 1988, while Congress was in recess, A was extended an ad interim appointment as Brigadier General of the Philippine Army. In February 1989, when Congress was in session, B was nominated as Brigadier General of the Philippine Army. B's nomination was confirmed on August 5, 1989, while A's appointment was confirmed on December 5, 1989. Question. Who is deemed more senior of the two, A or B? B. Question B. Suppose General adjourned without the Commission on Appointments. Acting on both appointments, can A and B retain their original ranks of colonel? Answer to letter A. A is senior than B, in accordance with the ruling in Summers versus Osaeta. The ad interim appointment extended to A is permanent and is effective upon his acceptance, although it is subject to confirmation by the Commission of Appointments. Answer to B. If Congress adjourned without the appointments of A and B having been confirmed by the Commission on Appointments, A cannot return to his old position, as held in Summers versus Osatea. By accepting an ad interim appointment to a new position, A waived his right to hold his old position. On the other hand, since B did not assume the new position, he retained his old position. Q. What is the nature of an acting appointment to a government office? Does such an appointment give the appointee the right to claim that the appointment will, in time, ripen into a permanent one? Explain. Answer. According to Sevilla versus Court of Appeals, an acting appointment is merely temporary, as held in Marrohomsar versus Alonto. A temporary appointment cannot become a permanent appointment unless a new appointment which is permanent is made. This holds true unless the acting appointment was made because of a temporary vacancy. In such a case, the temporary appointee holds office until the assumption of office by the permanent appointee. Disabilities and inhibition of public officers. Q. X was elected provincial governor for a term of 3 years. He was subsequently appointed by the President of the Philippines, serving at her pleasure as concurrent presidential assistant for public affairs in the office of the President without additional compensation. Is X appointment valid? 2002 bar. Answer. The appointment of X is not valid because the position of presidential assistant for political affairs is a public office. Article 9B, Section 7 of the Constitution provides that no elective official shall be eligible for appointment or designation in other capacity to any public office or position during his tenure, as held in Flores versus Drilon. Since an elective official is ineligible for an appointive position, his appointment is not valid. Q. M is the Secretary of the Department of Finance. He is also an ex officio member of the Monetary Board of Bangko Sentral ng Pilipinas, from which he receives an additional compensation for every board meeting attended. N. The taxpayer filed a suit in court to declare Secretary M's membership in the Monetary Board and his receipt of additional compensation illegal and in violation of the Constitution, and invoked Article 7, Section 13 of the Constitution, which provides that the President, Vice President, the members of the Cabinet, and their deputies or assistants shall not, unless otherwise provided in the Constitution, hold any other office or employment during their tenure, and also cited Article 9b, Section 8 of the Constitution, which provides that no elective or appointive public officer or employee shall receive additional, double, or indirect compensation unless specifically authorized by law. If you were the judge, how would you decide the following? The issue regarding the holding of multiple positions, and the issue on the payment of additional or double compensation. Explain your answers fully. Answer: if I were the judge, I would uphold the validity of the designation of Secretary M as ex officio member of the Monetary Board, as stated in Civil Liberties Union versus Executive Secretary. The prohibition against the holding of multiple positions by cabinet members in Article 7, Section 13 of the Constitution does not apply to positions occupied in an ex officio capacity as provided by law and as required by the primary functions of their office. B. If I were the judge, I would rule that Secretary M cannot receive any additional compensation, as stated in Civil Liberties Union and Executive Secretary. A cabinet member holding an ex officio position has no right to receive additional compensation, for his services in that position are already paid for by the compensation attached to his principal office. Q. Suppose A municipal mayor, went on a sick leave to undergo medical treatment for a period of 4 months. During that time, will B, the municipal vice mayor, be performing executive functions? Why? Will B at the same time be also performing legislative functions as presiding officer of the Sangguniang Bayan? Why? Answer: since the municipal mayor is temporarily incapacitated to perform his duties in accordance with Section 46, letter A of the Local Government Code, the municipal vice mayor shall exercise his powers and perform his duties and functions. The municipal vice mayor will be performing executive functions because the functions of the municipal mayor are executive. The municipal vice mayor cannot continue as presiding officer of the Sangguniang Bayan while he is acting municipal mayor. In accordance with Gamboa versus Aguirre, under the Local Government Code, the municipal mayor was deprived of the power to preside over the Sangguniang Bayan and is no longer a member of it. The temporary vacancy in the office of the municipal mayor creates a corresponding temporary vacancy in the office of the municipal vice mayor when he acts as municipal mayor. This constitutes inability on his part to preside over the sessions of the Sangguniang Bayan. Liabilities of public officers, preventive suspension, and back salaries. Q. Alfonso Bate, a supply officer in the Department of Science and Technology (DOST), was charged administratively. Pending investigation, he was preventively suspended for 90 days. The DOST secretary found him guilty and meted him the penalty of removal from office. He appealed to the Civil Service Commission. In the meantime, the decision was executed pending appeal. The Commission rendered a decision which modified the appeal decision by imposing only a penalty of reprimand, in which decision became final. A. Can Alfonso Bate claim salary for the period that his case was pending investigation? Why? Can he claim salary for the period that his case was pending appeal? Why? Answer: Alfonso Bate cannot claim any salary for the period of his preventive suspension during the pendency of the investigation, as held in Gloria v. Court of Appeals. Under Section 52 of the Civil Service Law, the previous provision for payment of salaries during the period of preventive suspension during the pendency of the investigation has been deleted. The preventive suspension was not a penalty. Its imposition was lawful, since it was authorized by law. B. If the penalty was modified because Alfonso Bate was exonerated of the charge that was the basis for the decision ordering his dismissal, he is entitled to back wages. Otherwise, this would be tantamount to punishing him after exoneration from the charge which caused his dismissal. Gloria v. Court of Appeals. If he was reprimanded for the same charge, which was the basis of the decision ordering his dismissal, Alfonso Bate is not entitled to back wages because he was found guilty and the penalty was merely commuted. Q. Simon Valera was formerly a provincial governor who ran and won as a member of the House of Representatives for the 2nd Congressional District of Iloilo for violation of Section 3 of the Anti-Graft and Corrupt Practices RA number 3019 as amended, allegedly committed when he was still a provincial governor. A criminal complaint was filed against him before the Office of the Ombudsman, for which, upon a finding of probable cause, a criminal case was filed with the Sandigan Bayan. During the course of trial, the Sandigan Bayan issued an order of preventive suspension for 90 days against him. Representative Valeros questioned the validity of the Sandigan Bayan order on the ground that under Article 6, Section 16, Number 3 of the Constitution, he can be suspended only by the House of Representatives and that the criminal case against him did not arise from his actuation as a member of the House of Representatives. Is Representative Valero's contention correct? Why? Answer. The contention of Representative Valero is not correct. As held in Santiago v. Sandigan Bayan, the suspension contemplated in Article 6, Section 16, Number 3 of the Constitution is a punishment that is imposed by the Senate or House of Representatives upon an erring member. It is distinct from the suspension under Section 13 of the Anti-Graft and Corrupt Practices Act, which is not a penalty but a preventive measure. Since Section 13 of the Anti-Graft and Corruption Practices Act does not state that the public officer must be suspended only in the office where he is alleged to have committed the acts which he has been charged, it applies to any office which he may be holding. Q. Maximo, an employee of the Department of Education, is administratively charged with dishonesty and gross misconduct. During the formal investigation of the charges, the Secretary of Education preventively suspended him for a period of 60 days. On the 68th day of the preventive suspension, the Secretary rendered a verdict finding Maximo guilty and ordered his immediate dismissal from the office. Maximo appealed to the Civil Service Commission, which affirmed the Secretary's decision. Maximo then elevated the matter to the Court of Appeals. The CA reversed the Commission decision, exonerating Maximo. The Secretary of Education then petitions the Supreme Court for the review of the CA decision. Is the Secretary of Education a proper party to seek the review of the CA decision exonerating Maximo? Reason. A. The Secretary of Education is not the proper party to seek a review of the decision of the Court of Appeals because he is the one who heard the case and imposed the penalty. Being the disciplinary authority, the Secretary of Education should be impartial and should not actively participate in prosecuting Maximo. National Appellate Board of National Police Commission versus Mamuaag. B. If the Supreme Court affirms the CA decision, is Maximo entitled to recover back salaries corresponding to the entire period he was out of service? Explain your answer. Answer. Maximo cannot recover back salaries during his preventive suspension. The law does not provide for it. Preventive suspension is not a penalty. During the preventive suspension, he was not yet out of the service. However, he is entitled to back wages from the time of his dismissal until his reinstatement. The enforcement of the dismissal pending appeal was punitive, and he was exonerated. Gloria versus Court of Appeals. Accountability of public officers. Impeachment. What are the grounds for impeachment? Explain. Answer. Under Section 2, Article 11 of the Constitution, the grounds for impeachment are: A. Culpable violation of the Constitution means intentional violation of the Constitution and not violations committed in good faith. B. Treason, the same meaning as in the Revised Penal Code. C. Bribery, the same meaning as in the Revised Penal Code. D. Graft and corruption, refers to prohibited acts enumerated in the Anti-Graft and Corruption Practices Act. E. Other high crimes, refers to offenses that strike at the very life or orderly working of the government. F. Betrayal of public trust, refers to any violation of the oath of office. Cruz, Philippine Political Law. Ombudsman, Section 5 to 14, Article 11 of the 1987 Constitution in relation to RA number 6770, or otherwise known as the Ombudsman Act of 1989. Q. A group of losing litigants in a case decided by the Supreme Court filed a complaint before the Ombudsman, charging the justices with knowingly and deliberately rendering an unjust decision in utter violation of the penal laws of the land. Can the Ombudsman validly take cognizance of the case? Explain. No, the Ombudsman cannot entertain the complaint. As stated in the case of Laureta versus Court of Appeals, pursuant to the principle of separation of powers, the correctness of the decision of the Supreme Court as final arbiter of all justiciable disputes is conclusive upon all other departments of the government. The Ombudsman has no power to review the decisions of the Supreme Court by entertaining a complaint against the justices of the Supreme Court for knowingly rendering an unjust decision. Alternative answer. Article 11, Section 1 of the 1987 Constitution provides that public officers must at all times be accountable to the people. Section 22 of the Ombudsman Act provides that the Office of the Ombudsman has the power to investigate any serious misconduct allegedly committed by officials removable by impeachment for the purpose of filing a verified complaint for impeachment if warranted. The Ombudsman can entertain the complaint for this purpose. Q. CTD, a Commissioner of the National Labor Relations Commission, NLRC, sports a number 110 car plate. A disgruntled litigant filed a complaint against him for violation of Anti-Graft and Corruption Practices Act before the Ombudsman. CTD now seeks to enjoin the Ombudsman in a petition for prohibition, alleging that he could be investigated only by the Supreme Court under its power of supervision granted in the Constitution. He contends that under the law creating the NLRC, he has the rank of a Justice of Court of Appeals and entitled to the corresponding privileges. Hence, the Ombudsman has no jurisdiction over the complaint against him. Should CTD's petition be granted or dismissed? Reason briefly. Answer. The petition of CTD should be dismissed. Section 21 of the Ombudsman Act vests the Office of the Ombudsman with disciplinary authority over all elective and appointive officials of the government, except officials who may be removed only by impeachment, members of Congress, and the judiciary. While CTD has the rank of a Justice of the Court of Appeals, he does not belong to the judiciary but to the executive department. This simply means that he has the same compensation and privileges as a Justice of the Court of Appeals. If the Supreme Court were to investigate CTD, it would be performing a non-judicial function. This will violate the principle of separation of powers. Q. Director Wow failed the lifestyle check conducted by the Ombudsman's office because Wow's assets were grossly disproportionate to his salary and allowances. Moreover, some assets were not included in his statement of assets and liabilities. He was charged of graft and corrupt practices, and pending the completion of investigation, he was suspended from office for 6 months. Aggrieved, Wow petitioned the Court of Appeals to annul the preventive suspension order on the ground that the Ombudsman could only recommend but not impose the suspension. Moreover, according to Wow, the suspension was imposed without any notice or hearing, in violation of due process. Is the petitioner's contention meritorious? Discuss briefly. For his part, the Ombudsman moved to dismiss Wow's petition. According to the Ombudsman, the evidence of guilt of Wow is strong, and petitioner failed to exhaust administrative remedies. Wow admitted he filed no motion for reconsideration, but only because the order suspending him was immediately executory. Should the motion to dismiss be granted or not? Discuss briefly. That is question letter B. Answer to the first question. The contention of Director Wow is not meritorious. The suspension meted out to him is preventive and not punitive. Section 24 of Republic Act No. 6770 grants the Ombudsman the power to impose preventive suspension up to 6 months. Preventive suspension may be imposed without any notice or hearing. It is merely a preliminary step in an administrative investigation and is not the final determination of the guilt of the officer concerned. Garcia v. Mojica, 314 Squa, 207. Answer to letter B. The motion to dismiss should be denied. Since the suspension of Director Wow was immediately executory, he would have suffered irreparable injury had he tried to exhaust administrative remedies before filing a petition in court. University of the Philippines versus Board versus Rasul. Besides, the question involved is purely legal. Azar Khan versus Banugan. Q. Judge Red is the executive judge of Green City. Red is known to have corrupt tendencies and has a reputation widely known among practicing lawyers for accepting bribes. Ombudsman Gray, wishing to clean up the government from errant public officials, initiated an investigation on the alleged irregularities in the performance of duties of Judge Red. A. Judge Red refused to recognize the authority of the Office of the Ombudsman over him because, according to him, any administrative action against him or any court official or employee falls under the exclusive jurisdiction of the Supreme Court. Decide with reason. Question B. Does the Ombudsman have authority to conduct investigation over crimes or offenses committed by public officials that are not in connection or related at all to the official's discharge of his duties and functions? Explain. Question letter C. Who are required by the Constitution to submit a declaration under oath of his assets, liabilities, and net worth? Answer. Letter A. Since the complaint refers to the performance of duties of Judge Red, Ombudsman Gray should not act on it and should refer it to the Supreme Court. His investigation will encroach upon the exclusive power of administrative supervision of the Supreme Court over all courts. Macera versus Vasquez. B. The Ombudsman can investigate crimes or offenses committed by public officers which are not connected with the performance of their duties. Under Section 13, Number 1, Article 11 of the Constitution, the Ombudsman can investigate any act or omission of a public official which is illegal. Velosa versus Domingo. C. All public officers and employees are required to submit a declaration under oath of their assets, liabilities, and net worth. Section 17, Article 11 of the Constitution. Sandigan Bayan, ill-gotten wealth. Q. Suppose a public officer has committed a violation of Section 3, B, and C of the Anti-Graft and Corrupt Practices Act, RA 3019, as amended, by receiving monetary and other material consideration for contracts entered into by him in behalf of the government and in connection with other transactions, as a result of which he has amassed illegally acquired wealth. Does the criminal offense committed prescribe? B. Does the right of the government to recover the illegally acquired wealth prescribe? Answer. A violation of Section 3, B, and C of the Anti-Graft and Corrupt Practices Act prescribes, as held in Presidential Ad Hoc Fact-Finding Committee on Behest Loans versus Desierto. Article 11, Section 15 of the Constitution does not apply to criminal cases for violation of the Anti-Graft and Corrupt Practices. B. Article 11, Section 15 of the Constitution provides that the right of the state to recover properties unlawfully acquired by public officials or employees, or from them, or from their nominees or transferees, shall not be barred by prescription. Administrative law. Q. Are government-owned or controlled corporations within the scope and meaning of the government of the Philippines? Answer. Section 2 of the introductory provision of the Administrative Code of 1987 defines the government of the Philippines as the corporate governmental entity through which the functions of government are exercised throughout the Philippines, including, same as the contrary appears from the context, the various arms through which political authority is made effective in the Philippines, whether pertaining to the autonomous regions, the provincial city, municipality, municipal or barangay subdivision, or other forms of local government. Government-owned or controlled corporations are within the scope and meaning of the government of the Philippines if they are performing governmental or political function. Q. State with reasons which of the following is a government agency or a government instrumentality. A. Department of Public Works and Highways. B. Bangko Sentral ng Pilipinas. C. Philippine Ports Authority. D. Land Transportation Office. E. Land Bank of the Philippines. A. An agency of the government refers to any of the various units of the government, including a department, bureau, office, instrumentality, or government-owned or controlled corporation, or a local government or a district unit therein. Section 4, Number 4, J. Introductory Provisions, Administrative Code of 1987, Mactan-Cebu versus Marcos. An instrumentality of the government refers to any agency of the national government not integrated within the department framework, vested with special functions or jurisdiction by law, endowed with some, if not all, corporate powers, administering special funds and enjoying operational autonomy, usually through a charter. This term includes regulatory agencies, chartered institutions, and government-owned or controlled corporation. Section 3, Number 10, Introductory Provision, Administrative Code of 1987, Mactan-Cebu versus Marcos. A. The Department of Public Works and Highways is an agency of the government because it is a department. B. The Bangko Sentral ng Pilipinas is a government instrumentality because it is vested with the special function of being the central monetary authority and enjoys operational autonomy through its charter. C. The Philippine Ports Authority is a government instrumentality because it is merely attached to a Department of Transportation and Communication. It is vested with the special function of regulating ports, and it is endowed with corporate powers through its charter. Endowed. D. The Land Transportation Office is an agency of the government because it is an office under the Department of Transportation and Communication. E. The Land Bank of the Philippines is a government instrumentality because it is vested with special function of financing agrarian reform. It is endowed with all corporate powers and it enjoys autonomy through a charter. Powers of administrative agencies. Q. What is quasi-judicial body or agency? A. A quasi-judicial body is an administrative agency which performs adjudicative functions. Although it is authorized by law to try and decide certain cases, it is not bound strictly by the technical rules of evidence and procedure. However, it must observe the requirements of due process. Q. The Maritime Industry Authority, or MARINA, issued new rules and regulations governing pilotage services and fees, and the conduct of pilots in the Philippine ports. This it did without notice, hearing, nor consultation with harbor pilots or their associations whose rights and activities are to be substantially affected. The harbor pilots then filed suit to have the new MARINA rules and regulations declared unconstitutional for having been issued without due process. Decide the case. Answer. The issuance of the new rules and regulations violated due process. Under Section 9, Chapter 2, Book 7 of the Administrative Code of 1987, as far as practicable, before adopting proposed rules, an administrative agency should publish or circulate notices of the proposed rules and afford interested parties the opportunity to submit their views. And in the fixing of rates, no rule shall be valid unless the proposed rates shall have been published in a newspaper of general circulation or at least 2 weeks before the first hearing of them. In accordance with this provision in Commissioner of Internal Revenue versus CA, it was held that when an administrative rule substantially increases the burden of those directly affected, they should be accorded the chance to be heard before its issuance. Administrative due process. Q. The SS Masoy of Panamanian Registry, while moored at the South Harbor, was found to have contraband goods on board. The custom team found out that the vessel did not have the required ship's permit and shipping documents. The vessel and its cargo were held, and a warrant of seizure and detention was issued after due investigation. In the course of the forfeiture proceedings, the ship captain and the ship's resident agent executed sworn statements before the custom legal officer, admitting that contraband cargo were found aboard the vessel. The shipping lines object to the admission of the statements as evidence, contending that during their execution, the captain and the shipping agent were not assisted by counsel in violation of due process. Decide. A. The admission of the statements of the captain and the shipping agent as evidence did not violate due process, even if they were not assisted by counsel. In Freighter International Line versus Court of Appeals, it was held that the assistance of counsel is not indispensable to due process in forfeiture proceedings, since such proceedings are not criminal in nature. Moreover, the strict rules of evidence and procedure will not apply in administrative proceedings like seizure and forfeiture proceedings. What is important is that the parties are afforded the opportunity to be heard, and the decision of the administrative authority is based on substantial evidence. Q. A complaint was filed by intelligence agents of the Bureau of Immigration and Deportation, BID, against Stevie, a German national, for his deportation as an undesirable alien. The Immigration Commissioner directed the Special Board of Inquiry to conduct an investigation. At the said investigation, a lawyer from the legal department of the BID presented as witness the 3 intelligence agents who filed the complaint. On the basis of the findings, report, and recommendation of the Board of Special Inquiry, the BID commissioners unanimously voted for Stevie's deportation. Stevie's lawyer questioned the deportation order. A. On the ground that Stevie was denied due process because the BID commissioner who rendered the decision were not the ones who received the evidence, in violation of the "he who decide must hear" rule. Is he correct? B. On the ground that there was a violation of due process because the complainants, the prosecutor, and the hearing officers were all subordinates of the BID commissioners who rendered the deportation decision. Is he correct? Answer of letter A. No. Stevie is not correct. As held in Adamson versus Amores, administrative due process does not require that the actual taking of testimony or the presentation of evidence before the same officer who will decide the case. In American Tobacco versus Director of Patents, the Supreme Court has ruled that so long as the actual decision on the merits of the case is made by the officer authorized by law to decide, the power to hold a hearing on the basis of which his decision will be made can be delegated and is not offensive to due process. The court noted that as long as the party is not deprived of his right to present his own case and submit evidence in support thereof, and the decision is supported by the evidence in the record, there is no question that the requirement of due process and fair trial are fully met. In short, there is no abrogation of responsibility on the part of the officer concerned, as the actual decision remains with and is made by said officer. It is, however, required that to give the substance of a hearing, which is for the purpose of making determinations upon evidence, the officer who makes the determinations must consider and appraise the evidence which justifies them. Letter B. No, Stevie was not denied due process simply because the complainants, the prosecutor, and the hearing officers were all subordinates of the Commissioner of the Bureau of Investigation and Deportation, in accordance with a ruling in Erlanger and Gallinger versus Court of Industrial Relations 110 Phil 470. The findings of the subordinates are not conclusive upon the commissioners, who have the discretion to accept or reject them. What is important is that Stevie was not deprived of his right to present his own case and submit evidence in support thereof. The decision is supported by substantial evidence, and the commissioner acted on their own independent consideration of the law and facts of the case and did not simply accept the views of their subordinates in arriving at a decision. Distinguish the doctrine of primary jurisdiction from the doctrine of exhaustion of administrative remedies. Does the failure to exhaust administrative remedies before filing a case in court owe said court of jurisdiction to hear the case? Explain. Answer. The doctrine of primary jurisdiction and the doctrine of exhaustion of administrative remedies both deal with the proper relationships between the courts and administrative agencies. The doctrine of exhaustion of administrative remedies applies where a claim is cognizable in the first instance by an administrative agency alone. Judicial interference is withheld until the administrative process has been completed, as stated in Industrial Enterprise versus Court of Appeals. The doctrine of primary jurisdiction applies where a case is within the concurrent jurisdiction of the court and an administrative agency, but the determination of the case requires the technical expertise of the administrative agency. In such a case, although the matter is within the jurisdiction of the court, it must yield to the jurisdiction of the administrative case. Letter B. No, the failure to exhaust administrative remedies before filing a case in court does not oust the court of jurisdiction to hear the case, as held in Rosario v. Court of Appeals. The failure to exhaust administrative remedies does not affect the jurisdiction of the court, but result in the lack of a cause of action, because the condition precedent that must be satisfied before action can be filed was not fulfilled. Q. Explain the doctrine of exhaustion of administrative remedies. Give at least 3 exceptions to its application. Answer. The doctrine of exhaustion of administrative remedies means that when an adequate remedy is available within the executive department, a litigant must first exhaust this remedy before he can resort to the courts. The purpose of the doctrine is to enable the administrative agencies to correct themselves if they have committed an error. Rosales v. Court of Appeals. The following are the exceptions to the application of the doctrine of exhaustion of administrative remedies. A. The question involved is purely legal. B. The administrative body is in estoppel. C. The act complained of is patently illegal. C. There is an urgent need for judicial intervention. E. The claim involved is small. F. Grave and irreparable injury will be suffered. G. There is no other plain, speedy, and adequate remedy. H. Strong public interest is involved. I. The subject of the controversy is private law. J. The case involves a co-run to proceeding. K. The party was denied due process. L. Decision is that of a department secretary. M. Resort to administrative remedies would be futile. N. There is unreasonable delay. O. The action involves recovery of physical possession of public land. P. The party is poor. And Q. The law provides for immediate resort to the court.